All right, for this video, I wanted to address a question I get a lot when forming a new entity. And it's always, okay, I want to have an S corporation election because I want the pass-through tax treatment. I want to be saving on self-employment taxes. But before I go down this path of making the election, which entity do I set up? Do I set up a corporate entity, or do I set up an LLC, something else? What do I do? So it's a good question, and I'm going to address it based on my experience, what I feel is the best appropriate route to take. But let's look at some of the background information on what you need to be an S corporation, and then we'll look at, is an LLC better or is a corporate entity better to start with? So the first issue is always, there's no such thing as an S corporation under state law, right? So if you were going to form an entity in Florida, Wyoming, Delaware, New York, Nevada, it doesn't matter where it is. If you called up that Department of State office that processes the applications and you said, I want to launch an S corporation, they'd probably hang up the phone on you, right? I mean, they'd be like, well, I don't know what you're talking about. And they're right. The reason is S corporation is not an entity legally formed or in existence under state law. It's just a federal tax election. So what that means is you have to set up an entity first that is an eligible entity to make the S election. And then after you've got that entity set up, assuming you comply with all the other requirements, you can make an S-corp election by filing the 2553, okay? So the first starting point here is always, what kind of business are you going to be running and what state do you operate in? So that's the second bullet point here I have on check your state law provisions. So what I mean by that is some states will actually restrict the type of entity you can form depending upon the business that you're going to be conducting within the state. Okay. Now you can still make the S election, but you have to set up an entity that complies with the state regulatory requirements. Otherwise, you just can't even conduct business, period. So for example, in Florida, for many years, if you wanted to open a law firm or an accounting firm or a medical practice, the entity had to be some type of professional corporation, right? So it had to be a PA, which is a professional association. It had to be a PC, which is a professional corp. It had to be a regular corp, or it had to be, a lot of times you could set up an LP, a limited partnership or general partnership. You were restricted from using the LLC. They would not allow you to use an LLC to launch this type of business in the state of Florida. Now, regulations have since changed. Now, Florida has a PLLC, which is a professional limited liability company. So that option is on the table. But the point I'm trying to make is all of these entities might be eligible to make an S election, but if the entity type that you set up isn't permissible under state law because of what you're doing, you're already off to a bad start, right? Forget about the S election. You're in violation of state statute conducting business under that entity type. So always check first with what type of entity you're allowed to use. Now, what are the general types of requirements you need to be an S-corp? Well, the first one is always, it has to be a domestic entity. Okay, so you can't set up an entity in Bermuda, make an S election, not going to work, right? So it has to be a domestic eligible entity, and you have to file the election via 2553, right, where you make the election, you list all the U.S. shareholders, and you sign off on it. The other limitation is all of the owners in that corporation have to be U.S. natural persons, right? So U.S. individuals. You can't have a U.S. corporation as a shareholder. You can't have a U.S. LLC as a partnership as a shareholder. They have to be natural persons, and you've got to have 100 or less shareholders. Now, there's some unique exceptions for subchapter S trusts, or certain types of estates can be shareholders in S-corp. But generally, what we're talking about here is natural persons, so individuals that are U.S. tax residents, no entities. And then the last one is always, you can only have one class of stock, right? So one class of stock simply means that however much stock you own in the company, that is how much income or expense distributions are allocated to you. So if I own 40% of the company, I am allocated 40% of the profits or losses. I'm allocated 40% of the cash dividend distributions, and that's just how it works. Okay. Now, let's talk about, okay, so now let's get into the corporation versus LLC. So let's say you set up a corporation. So this is a regular Inc., right? INC, corporate entity. Corporations are governed by the terms in their articles of incorporation, the corporate bylaws, and then in some cases, if you have closely held companies, you have a shareholders agreement. Now, corporations, the one drawback with corporations is they have a lot of corporate formalities, right? So what that means is that under state statute, the corporation needs to have board meetings, shareholder meetings, keep minutes of all this, hold special meetings to vote on certain matters. All of this stuff, which doesn't seem like a big deal, but it's still required just to maintain the entity in good standing, versus with an LLC, you don't need any of that, right? LLCs are governed by their LLC operating agreement, so whatever you have in the LLC agreement is sufficient, right? You don't have to actually hold these meetings in order to maintain the LLC in good standing. The other issue is just the liability protection. And so this is a big one, right? So corporations, so corporate stock is for most cases considered personal property, right? Versus LLC membership units are not. Now, why that's significant is because if you as an individual get sued, a creditor can take your assets, right? They can take your bank account, they can take your house, they can also take your ownership interest in other companies. Now, corporate stock, because it's personal property, they can actually take stock that you have in a corporation, right? So whether it's a closely held corporation or if you hold stock in Google or Tesla, Apple, they can take that and satisfy the judgment with the sale of those proceeds. LLC membership units, they can't do that, right? So with an LLC, a creditor, if they sue you personally and they get a judgment, they can't take your LLC units. The best they can do is normally what's called a charging order protection. So they can place a lien on the LLC, and which says that, okay, if any cash is distributed from the LLC to you as an owner, we can take a piece of that or all of it, but we can't actually take your LLC units, and we can't actually become an owner of this company and start directing the business. Not the same protections with corporations. So that's why corporations generally much less favorable to set up, particularly in a closely held context, because of that potential exposure. Now, one thing I see a lot of online is CPAs will tell you, well, LLCs, the operating agreement can provide way too much leeway as far as how to allocate income, distributions, all this kind of stuff. And the issue they're talking about is different classes of stock, right? So LLCs can have Class A, B, C membership units, all these special allocations. And it's true that an LLC operating agreement drafted that way could violate the S-corporation tax status. However, if you're doing it correctly from the beginning, the LLC operating agreement can have provisions in there that say, look, we want to be an LLC, taxed as a C-corp, so we're going to do everything we need to comply with that tax status, okay? So if the LLC operating agreement is drafted incorrectly, you don't have these problems. And so when they say, well, just set up a corporation, corporations can have the same issues, right? So corporations, if you look at the articles of incorporation, within the articles of incorporation, you're supposed to state how many classes of stock you have, common, preferred, any kind of special voting rights. So you can have a C-corp set up that has Class A, B, C, D, and so on in common shares, preferred shares. So you're in the same position. So it's a bit disingenuous when they say, well, if you want to make sure your S-corp status is maintained, just set up a corporation because you don't have the same LLC issues. That's just not true. Corporations can absolutely have terms in the articles of incorporation or in the bylaws that would violate the S-corporation tax status. So, if I'm recapping everything and wrapping it all up here, my initial suggestion to you is always try to lean towards the LLC. Obviously, like I said, with the state statute issues, if you're in a state that doesn't permit LLCs, given what type of business you're going to be conducting, you can't use it. So, okay, then you have to use a corporate structure. But LLCs are the best of both worlds as far as liability protection, ease of ownership, ability to make that S election. The point is, when you have that LLC and you draft that LLC operating agreement, it has to be tailored to an LLC that's making an S corporation election. Do not simply use some boilerplate LLC operating agreement you downloaded online, or you got from one of those companies that just is kind of just setting up LLCs 100 a day. They're not actually taking any care to figure out what it is you're doing. So the LLC operating agreement does need to be precise to what you're doing, and it does need to be tailored to this S corporation election. So I hope that was helpful, answered any questions you had. If you have any other future questions, please feel free to leave a question below on the video. I try to answer as many as I can, and I look forward to seeing you guys on the next video. Thank you so much. Bye.